A New Mexico cop who thought he'd gotten out of a DWI charge found out today he is not out of trouble after all. Now he wants to take his case all the way to the U.S. Supreme Court. Here's News 13's Lizzie Mitri.
It's been rough.
Abraham Baca was a state police officer off duty when Rio Arriba County deputies pulled him over 5 years ago near Espanola. The charge, aggravated DWI. A criminal complaint shows he failed field sobriety tests. But when the case went to court later that year, a magistrate judge threw it out on a technicality.
We had a trial in magistrate court where I was intending to prove his innocence. That's when the magistrate acquitted Abraham.
He says case closed. You can't try someone twice for the same crime. The prosecution says not so fast.
There was no acquittal here.
The Attorney General's office argues the case was dismissed, but not because a judge decided Baca was not guilty. So prosecutors say Baca still needs to go on trial.
What we have is a procedural termination of the trial without a determination of guilt or innocence.
Today, the state Supreme Court agreed.
The New Mexico Supreme Court actually cited to and relied on the United States Supreme Court precedent regarding double jeopardy.
But Baca's attorney is ready to take the case to the U.S. Supreme Court, saying it's a constitutional rights issue.
The point being that nobody's supposed to face trial successively if they were acquitted. And that's really what we're making a stand against.
Since resigning from state police, Baca is now working for the very agency that accused him of driving drunk in the first place, the Rio Arriba County Sheriff's Office. Lizzie Mitri, KRQE News 13.
And the odds are against the U.S. Supreme Court hearing Baca's case. That high court only hears about 100 or so of the more than 7,000 cases it is asked to take each year.